So we were busy talking about the relationship between the union and the member, and basically just discussing the way in which the rights of the member relative to the union, meaning in their relationship with the union, right, are protected. And you said that their rights are protected by the LRA. Okay, and you said what else? In terms of the
basic conditions of employment.
Yeah, basic conditions of employment. Yeah,
and then the Constitution of the Republic of South Africa.
Yeah, under the Constitution, I understand, because the Constitution is the basis of all legislation, if I understand it.
Yes.
But then I don't understand the basic conditions of employment. How those conditions apply to the relationship between a member and the union, because a member is not an employee of the union.
No. It applies in terms of the relationship between the member and the employer.
Okay. So which rights cover the rights of the member, right, in their relationship with the union? Because the union derives its constitution as per the LRA, or is it as per the LRA?
Yes, it is as per the LRA.
Okay.
Because especially the part that talks about trade unions, that regulates trade unions, because the LRA will talk about trade unions must be registered, trade unions must have a constitution, the constitution must talk to the operations of that particular.
Okay, so you're busy explaining the relationship between the Constitution and
there is in terms of the union, as far as I can recall, it only talks about, now in the Constitution will talk of the union will talk about the relationship between the union office and the shop stewards. Because the union constitution would regulate the relationship between the union office and the shop steward. But in terms of the employees, the employees, they only become members of the union. So it's more like a situation where you have somebody who is actually paying subscription for a service to be rendered. Now that employee or member,
they're a customer.
Like a customer, yes. They're like a customer. Like when you join Legal Wise, you subscribe to them, and then they will tell you basically that for the fee that you are paying, these are the services that you will render to you. And if you are not happy with my services, you have the right to then withdraw from the union and join another one. So there is no contract per se that we will have between ourselves and the member.
But then wouldn't the membership form be the contract?
To an extent. Look, remember, a contract has terms and conditions. Now, the membership form basically states that by virtue of you having completed the form, signed the form, you are now a member of the union. And then we submit the form to the employer to make the deductions. So,
but then when you sign the form, you become a member, but membership has terms and conditions. And those terms and conditions are outlined in the Constitution of the union.
But the terms, yes, but it will basically talk about any employee can join the union. And it will probably also talk about the
You mean the form? Do you mean the form, or do you mean the Constitution?
No, not the form, the Constitution.
Mm-hmm.
The Constitution. Mm-hmm. Because a member joins And if the member is not happy, then the member can resign. That's basically what it stipulates.
Yeah, but it also stipulates that if the union is not happy, the union can discipline the member and kick the member out through a disciplinary process that it dictates, that it details in the Constitution, right? So the union cannot simply tell the union the member to leave because, it could face some consequences, and essentially that's what I'm trying to get at, is that where do those because the way that I understand it is that those consequences are governed by civil law, right? And that's how basically members can take the union to court, right?
Yes.
Yeah, but then the Consumer Rights Act is also a civil law act, isn't it? I mean, you fight it in civil court.
Yes.
It's not in criminal court. So
it's not.
So for me, it's my understanding that the Consumer Rights Act, considering that it covers customers, and the member is a customer, a paying customer for services, right? It should cover their rights, protect them from just being kicked out of the union for no reason, without due process.
No, in terms of that, I think it is only the Labor Relations Act that would govern the process or the relationship between the union and the member or the employee.
Okay, just hold on.
The union. Because of that, yes.
Yeah. If I signed up with LegalWise and subscribed to them and paid them, I would be a customer covered by the Consumer Rights Act, right?
That's right.
Okay, but then
covered by
the Consumer Rights Act.
I'm not sure about that.
Because LegalWise is a well, I'm not sure I fully know everything about it, enough about it, but I understand it to be a private company, not a state-owned enterprise.
But now the issue then will then be, if let's just say I'm a member of LegalWise, and for some reason I'm not happy with LegalWise. Where do I go when I want to complain?
Okay, so let's take your question. You're not happy with LegalWise, right? And by saying that, you mean you're not happy with their service delivery, right?
Yes.
Yeah. So the Consumer Rights Act, it as far as I know, it does give you an avenue to take them to court, or to challenge them, or to sue them, right?
Yes.
For not sort of holding up their end of the deal in terms of the transaction. You pay every month, they're supposed to provide you a service.
Yes.
Yeah. In the same way that you can take an insurance company to court. Because if you look at LegalWise is basically insurance. But the service they provide is legal services. You pay per month in case you ever need them. Right? And there's a registrar as well. You can go complain to the registrar and then escalate it like that through the civil court process to try and get the remediation you want.
Yes, but you see, in this instance, unions are regulated by the Labor Relations Act. So, in essence, everything that happens that pertains to labor relations, was, remember, the relationship between the unions and its members are issues that deals with labor relations.
So when members take the union to court,
they would most probably have to rely on the statutory bodies that deal with labor relations. Because everything is informed by the labor relations and not by any other statutory, such as your consumer and so on.
Yeah.
I don't, in my view, I've never heard of such situations.
Would you say
situations before?
Yeah. Would you say that the services that unions provide members are products? They are products and services, like how an insurance company will say a certain insurance cover is a product because it's a service.
No. That's totally different. Totally different, because, I mean, all complaints, whenever members or anyone that has joined a union complains, they would most probably use statutory bodies such as the CCMA your labor court and so on.
Mm.
And I'm sure they can also use high court, because I think high court is equivalent of the labor court. So those two courts are basically on the same level.
So maybe you can just educate me. If I'm a member of your union, what are my rights relative to just our relationship? I'm a member of your union. What are my rights?
Your right. You have a right to be represented.
Okay.
At any to be represented at work.
Mm-hmm.
The right to be represented at any of the statutory bodies.
Mm-hmm. And I have the right to disciplinary process.
And to be fairly represented. So it's all about representation.
If we have a conflict within the union and the union is instituting disciplinary procedure against me, who represents me in that relationship?
If you are a member of the union.
Mm-hmm. And I ask you this because if I'm fighting with my employer and the employer is instituting disciplinary procedures against me, the union represents me. Am I correct?
That's right.
Yeah. But now if I'm now unhappy with the union, or the union is unhappy with me and they're instituting disciplinary procedures against me, who represents me there?
Okay, the only level of employees that we institute disciplinary action against would be your shop stewards. Now, okay, there are employees as well. Now, look, we would also follow, the disciplinary code of conduct that would state that because you have to be read your rights when you are being taken through a disciplinary hearing, where it would say you have a right to representation. You can be represented by a fellow colleague. The same goes with when the company's disciplinary code of conduct would say you can either be be represented by a shop steward, fellow employee.
Can I have a lawyer there?
No.
I can't have my lawyer. Okay, so let's talk about this. If I'm going through a disciplinary procedure instigated by my employer, can I bring my lawyer there?
No, you basically can't.
As far as I know it, and I discussed this with the CCMA when I was doing the interview, they said you can have a chairperson coming from outside.
Yes.
So that can't be the
chairperson.
Yeah.
They
have to be impartial.
Yes. So the chairperson is the one that will be presiding over a disciplinary matter. Now, in terms of being impartial, is another matter that is open for discussion.
But no, the reason why I'm saying that is because the chairperson cannot be my lawyer because they won't be impartial, right? And they're my lawyer, so they can't actually chair over the whole proceeding because their bias would be leaning to my side, right?
Question that we ask ourselves is who appoints the chairperson? Who pays the chairperson?
Yeah, that's basically what I asked the CCMA, and they said the chairperson is appointed by the employer because the disciplinary process is seen to be the employer's procedure.
Yes, it is their prerogative. It is their procedure. So often they would say the impartial or the independent chairperson will be impartial. And it is never like that.
Yeah, no, it's never like that.
They are being paid. They are being paid. So obviously, yeah.
Yeah. Look, that I understand. Okay. So the union will be there with me. There will be a chairperson who's we agree won't be impartial, but at least the union will be there with me, representing me.
Yes.
But now, in the case where now I'm the member and the union wants to kick me out and they're following a disciplinary procedure because I brought them into disrepute, right? Now, who can? So you're saying basically I can bring a fellow member to come and represent?
Fellow member, fellow employee. a fellow member can actually can be used in a disciplinary that will be done by the union.
Okay.
It's just that it makes it so much difficult because, I mean, in my experience, I've never had a situation. It's very rare that you'd find a member bringing the union into disrepute. But I know of an experience, a recent experience. It was this year, but it was with one of the other unions. I don't know what their structures are, whether but those were shop stewards, not ordinary members. That is why I'm saying it is rare where one would find an ordinary member, because the Constitution would not talk about discipline of an ordinary member, but it would talk about a shop steward who's also an employee of the company. So they are also in leadership positions. Because as a shop steward, you are a leader, and as a leader, you account to the union. And if for some reason you have had misconduct, then the union will then discipline you.
I have discussed this issue with some other people from the union space about these positions within these office bearing positions within unions. Because I mean, if you look at a shop steward is elected by the members, right?
That's correct.
Okay, but they account to the union, not the members.
They account to the union,
not the members.
Well, they account to the union as well as the members. They account to the actually now that you are mentioning it, remember because sometimes, I mean, there's this thing of when a member is not happy with a shop steward, they will resign from the union. And the reason that they will side will be that the shop steward sold me out. The shop steward did not do what he was supposed to do. The shop steward is in the pockets of the employer. And we have had such situations where I would tell the members, but you have elected him, and you are the people who must unseat that person.
But then to unseat him, wouldn't he have to undergo a disciplinary process?
Not necessarily. Not necessarily, because if a group of employees come and say this particular shop steward has done this and this and this and this, and they sort of petition that the person be removed. What we would then do is, instead of going through that process, where we would want to find the person guilty for misconduct and all of that, we would then call the shop steward in and say, look, we have received this complaint, and now the members are not happy. So this is actually costing the union. We still want to maintain that relationship with you as a member, but we would recommend or advise that you step down as a shop steward.
Okay, so you're advising. Yeah, you're advising. Yeah. You're not forcing him to step down. You're advising.
We're not forcing the person to step
down. Because you have no power to force it. Am I correct?
Yes.
Yeah, because the Constitution.
This is the first step. But if the person says, no, I did not do it, then we would obviously, I think unions work different. The other union would use a particular process, and then another one will use another process. But we are flexible, because we would say, this is the situation. Remember, when our members are not happy with you as a shop steward, it means one thing. They would want us to take action against you. So for us not to go through that process, we would to step down. But if he then does not want, because we already have some form of a mandate to say he must be removed. And if he refuses to step down, then we will say, if you don't step down, it's the same as, your political parties when they say you must step aside. And if you refuse to step aside, then they take action against you. So we will then say, if you don't want to step aside, then we will then have no other option than to, subject you to an internal process.
But then whatever happened to democratic centralism?
Because we want to maintain this relationship.
Yeah.
No, not a membership per se, because obviously when we take this person through disciplinary hearing and the person is subsequently removed as a shop steward, chances are that the person might resign as a member of the union. So it is there, but that is why we want to do this as amicable as possible, to say you should understand that if you don't step aside, the consequence that we will have is 50 members resigning from the union because of one person.
Yeah, I know. Yeah,
so,
and that is
yeah.
Okay, so all right. So one question I have for you is, if I'm one of your members and I get fired for a good reason, objectively from your point of view as a union, from outside, okay, I get fired for a good reason, but I'm your member and I've been paying my subscriptions, and I'm not happy with being fired. Okay, and I want to take this decision to task to the CCMA and even escalate it to Labour Court. Okay.
Yes.
Will I be able to say, I understand that you agree with my employer, but you're still my union, and therefore you must assist me in taking them to task to Labour Court, because I don't see it that way.
I mean, there is no way unions can ever agree with employers when employers fire their members. Because, I mean...
No, I'm talking about an individual member. So, I look, as we understand it, there are bargaining agreements, right, that detail, yes, that have included in them the best working conditions for employees, yes, and employers and so on. So I broke the rules according to those, those documents.
The employer.
No, okay. I broke the rules as a member, as an employee. Okay, so objectively, when you look at it as a union, the employer has done nothing wrong. They are following the agreement as per the discussions with the. But then for me, I'm not happy because I've been fired. I don't want to be fired, and I want to fight this. And I've been paying you as my union, and I'm calling you now to action to represent me in the labor courts and CCMA and so on as I escalate this thing. I've been making my payments. Are you gonna? Because I don't remember reading any. I've read COSATU, I've read NUMSA, I've read a couple of others. I don't remember seeing any. And correct me if I'm wrong. I don't remember seeing any clauses within those constitutions where they say we will not represent you where we see that the employer was acting in good faith in firing you. You broke the rules. You know according to the procedures you've been fired, and it's been fair, right?
Yeah.
So
Yeah, that is what I'm saying. Yes, the employer may be of the view that they have acted correctly in terms of their disciplinary code of conduct. They may even try to convince the union to say this person has broken a particular rule that he or she was aware of. But we are duty bound to our members, irrespective, because whether the member was in actual fact guilty and ultimately dismissed, we will still refer the matter to the CCMA. But even before we refer the matter, we'll tell the member that, look, according to this, if you have assaulted a superior, right, that's an instant dismissal. Now, ours is to uncover the reasons. Yes, you can't assault anyone at a workplace, but now we go further and try to uncover as to what led to whatever happened, because the employer will just look at the action that came from you by slapping or assaulting your superior, but they will not look at the circumstances surrounding your action as to what led to that. Were you provoked? How were you provoked? And all those kind of things.
Yeah.
So for us now, we'll go to the CCMA so that the CCMA can make a ruling.
Because there's always a chance that something was missed.
Was fair or unfair.
Yeah. Because there's always a chance that something was missed. Ne?
Yes. So we go there and then we'll represent the employee. And if needs be, the CCMA upheld the decision. We will then assess the entire proceedings and everything up to where we will then advise the member to say, look, we don't have prospects of referring this matter to the labor court. But is it still the member's decision to proceed to labor court either way, or is it the union's decision? That's what I'm asking. Yes, it is still, because the member can actually sort of not. It has never happened before, but we still have the discretion to exercise. Okay. We still have the discretion to exercise, because we don't just refer matters for the sake of referring them. Because if something is upheld, a decision of the employees upheld at the CCMA, then we can still use our discretion to say, okay, let's refer it, because obviously there will be points that we will be looking at, and we'll explain that to the member to say, the commissioner was biased. The commissioner, did not take this and that into account when we presented our case. Yeah. Or a whole lot of things. So that there is exceptional circumstances that would actually make us to refer matters to whichever statutory bodies. And all right. Last question. Here, this is not so much of a question, but more of, I'm going to read some statements that I'd like you to just comment on. All right. There's 3 statements here. Okay. Okay. Similarities between unions and labor brokers. Similarities between unions and labor brokers. Labor brokers deploy temporary staff to work for a client temporarily. Right? Yes. Okay. A union deploys its members temporarily to action against the employer. Can you comment on that? Unions? Can you repeat one of the unions? Unions deploys its members. A union deploys its members temporarily to action against their employer, if needed be. I'm talking about something like a strike. To action against their employers. Yeah, like in the form of a strike. Because a strike is an action, that's right? Yeah. So basically, if there's a dispute, if the union declares a dispute, and the members decide, okay, we're going to go on a strike, or the union decides we're going to go on a strike, then it's called a strike action, and it is against the employer, isn't it? Yes, but remember that cannot be a similarity, because in terms of the labor broker, those employees are duty bound to because if they don't do that, they are not going to be compensated. And then the members are exercising their right, because that is a right. The labor broker, if the labor broker says to its workers, we are now assigned to go and work for that company, they cannot refuse and say, no, I cannot go to that company, because if they refuse, then they don't have a job.
Yeah, but then in the same way,
But
members cannot refuse going on a strike, because if they refuse, they cannot win. They cannot get the deal they want. They cannot get the leverage they need to use in the negotiation.
they have a choice. Labor brokers, employees don't have a choice.
Okay, all right.
So
yeah,
a strike is by choice.
a strike is by
And
choice.
there's processes. Yeah, there's processes that are followed, such as balloting. Now the balloting system would be, I'm now going to exercise. Remember, with that process, some of your members, because there is this belief from some of the members, you cannot refuse. Because we all we want the same thing out of the employer. Now, if there is a division in terms of, whether we should go and strike or not, then you go to balloting system, where all of them will ballot. It's a secret ballot. Yes. And then if the majority of them says no to a strike, then there is no strike. If the majority says yes to a strike, then there is a strike. So that it's a choice they make. So if they don't want to strike and they are willing to forfeit whatever that we were fighting for, it is their choice.
All right. So here's the second statement. Working conditions of temporary staff, as in labor broker, staff that works for labor brokers.
Yes.
They are determined, or they should be determined. I'm saying should be because I don't know exactly how they're determined. But they're determined by contractual agreement between the broker and the client. Correct me if I'm wrong there, because I don't know. Right?
Yes.
Okay. So that's working conditions of temp staff should be determined by contractual agreement between the labor broker and the client. Right? Then on the opposite side, those of workers should be determined by contractual agreement between the union and the employer as its client.
So when the contracts are between two parties, basically, on the side of the labor broker, the labor broker has a main agreement between them and the employer for the type of services they ought to render. So
the employer being the client in this case.
The client, yes, the client. So the client would give the labor broker a tender and say, look, this is. I think they will all tender because they will most probably three labor brokers, and they will take the one that is not necessarily the best, but that is reasonable. And that does a better presentation than the others. That's a tender agreement of what services they are going to render to the client, and then between the labor broker and their employees is a contract of employment that is in line with the Basic Conditions of Employment Act. Now, with your employees and the employer, so the union does not enter anywhere in terms of how your relationship with the employer will be regulated in terms of the contract. But where we come in is employers oftenly include unlawful stipulations in the contract. There were instances that I previously picked up where the employer would say to the employee, in the event that you join a union, a trade union, you are to inform the employer within 7 days of joining the union. So the employee is not obliged to inform the employer that he or she has joined the union, because it's between the employee and the union, because once the employee has joined the union, then the union will submit the joining form to the employer for deduction of subscriptions without no questions asked. Because for as long as the employee has signed the application form and has given instruction for a debit order to be made, and it's also duly signed, then there's no questions that they can ask. Maybe the only question they can ask is, let's just say it's one employee. They can call the employee and say, we just want to confirm whether this is your signature.
Okay.
Not even to ask, did you complete this form?
Yeah, just, is this your signature?
We can see your name here and everything, and we see signatures. The only thing that we want to confirm is this your signature, yes or no? You can see that it's a union form. That's the only thing. Now, if it is where we seek organizational rights, obviously we may not have a union in that workplace. Then we take this bundle of membership forms and we go to the employer. We send them to the employer and say, we want to start a relationship with you. These are the people within your company that have joined the union. Let's meet. And then they can basically do a verification exercise. And that verification exercise is done. We have our first meeting to discuss the process. And then after that, we then embark on a verification exercise where we have all the employees who have joined to come to say, yes, I have signed here. I have no objection and so on until that is finalized, and then they implement.
Look, so as far as I understand it, right, the fight that unions have been waging against labor brokers, so far it has yielded legislation that forces labor brokers to employ casual workers after they've worked for 3 months, right? So it basically blocks labor brokers from employing someone casually for over 3 months. Okay. So now the thing is, while a person works for a labor broker as a casual worker, meaning for a period under 3 months, I understand that they're not protected by the Labor Relations Act because they're not an employee. Correct me if I'm wrong.
That person is an employee for as long as the person works for a full month. But if you work, if he is regarded an employee, but if you work then less than 21 days, then it's a different situation.
What is a casual worker?
A casual worker is somebody who works for less than 21 days. But then employers would hire casuals, would hire people for a period of 3 months and more, and call them casuals.
Yes, for a period of 3 months. That's what I was talking about. But this information that you just gave me is brand new to me, where you're saying that no, if you hire someone casually and they work for you longer for more than 21 days, they automatically become regarded as an employee.
That person is an employee, yes.
I must have missed it.
Yeah.
So can labor broker employees? Wow. So what is because I'm confused. What is an employee that is not hired permanent? Are they a contract employee? Are they on contract?
Yes, they are called FTCs, fixed term contract employees.
Fixed term contract.
Yes.
And what's the shortest amount of time you can have what's the shortest length of a fixed term contract? If
it depends on a fixed term employee can work for a period of 3 months and be terminated. Or a fixed term employee can work for a period of 36 months. Now, the issue then becomes problematic when a fixed term employee works for more than 3 months.
Yes.
And then the challenge that the employer will sit with is when we then challenge the employer by saying, this person has been working for more than 3 months. In terms of case law that came out, this person ought to be employed permanently because this person has worked for 4 months or 5 months or so. Now, because your labor brokers, they exploit, these people, they will let them work for a period of 3 months, terminate the contract, and then hire somebody else. Then you'll sit at home for 3 months, and then they'll call you after 3 months because now they want to change and then take somebody else.
But why not? Because you said why not just have them work for 3 months, terminate the contract? Because the contract is 3 months. The shortest time you said is 3 months. Yeah. Why not just hire them again on a 3-month basis again? Why just terminate them and hire someone new?
Because once they do that, they are running away from this thing of the person would have worked for more than 3 months, and then they'll be compelled to appoint them on a permanent basis.
Yeah.
And some of the labor brokers, even companies that has fixed term employees, because they employ them on a fixed term, but for 1 month. And after, because they believe that because if we employ them for 3 months continuously, then we'll be forced to or compelled to appoint them permanently. Now, what they do is they come with this trick of employing people for 1 month. Say your contract is from the 1st of November to the end of November. And then the contract will expire, and then they'll call you after 10 days because there will be a gap in between. It won't be regarded as continuous. But because of that, those gaps, you can still challenge them and say, but this is a rollover contract. Even though because they are being exploited, because they are running away from appointing them permanently. I mean, if you have somebody who works for a month, and then after a month takes 5 days break or 10 days break, and then get appointed again. And then at the end of that month, take another 5 days. But I mean, that's exploitation.
Yeah, it is.
At its worst.
It is.
So you can challenge them even at the CCMA and then present your case, and then the CCMA or the labor court for that matter can then make a judgment or a ruling on the matter.
All right,
so those are challenging because we don't know what's going to happen, but it's all about how you present your case, and then you take it from there. I've got an instance where somebody, the employer, is charging somebody for, they say it is gross dishonesty. Now, the person works on a farm where there is redundant timber, pieces of wood, timber that has been rained on, rotten or so. Now, the person picks that up because they are staying in a shack somewhere, want to make fire. I mean, it's been lying there for how long? But now, the person took that in the view of other colleagues, just took it because there are others that took before him, and they always, whenever these things are lying there, they pick up and go. Now, they happen to be seen by one of the managers, and then the manager said, no, you must come back with those pieces of timber, not a lot. And then they took them back, they get charged. They get charged, go through a disciplinary hearing, and then after the disciplinary hearing, then the employer coerced them to sign a mutual separation agreement.
Meaning,
now,
like he's resigning. Like they're forcing him to resign, basically, if I understand.
So something like that. But in this instance, you see, a forced resignation, you can still challenge it. But then with a mutual separation, we are entering into an agreement to say, because we don't want bad blood between us, I know what I did was wrong. I don't want you to say you have dismissed me on my records or UIF documents and so on. And the employer will then also say, because my document as a mutual separation agreement document, you are now prohibited from taking the company to the CCMA. Because it's an agreement between us. We are now separating. The problem with this, and I always say to people, do not sign anything documents that you do not understand. It is best that you do not sign at all, even if they say sign and they force you to sign. You say, no, I'm not going to sign. They can't do anything to you because you have the right to refuse to sign a document that you don't understand, unless it is your time and attendance document. You see, because they do find things that you don't understand, and those things count against you. So the first thing, when I saw the MSA, I was told that the person is taken to a disciplinary hearing, and then I wanted the outcome of the disciplinary hearing. They said, no, we'll send the documents. We sent the document. In my mind, I'm thinking, okay, I'll wait because they've got 30 days within which I can actually refer the matter. Because if I refer the matter to the CCMA after 30 days, I must apply for condonation and explain to them why I'm late. So eventually, when they send the document, the first thing that I saw is, this is an MSA. Then I called the guy and asked, why did you sign this document? They forced me. They said, no, but I mean, no one can force you. They cannot force you. They have to point you with a gun. That's when they force you. And now, because the problem with that is this guy is not legally inclined or have the legal capacity to understand the legality of this document. The first thing that they were supposed to do is to allow him to be represented by a shop steward, which they did not do. And because of the document itself, it's a legal document, and he has to understand the consequences of signing the document. They did not explain that to him. They just say, sign. And the person signed, and even say he cannot refer the matter to the CCMA. What I then did is I referred the matter to the CCMA anyway. And then I explained to the CCMA, but this person was coerced. This person did not understand. This person is not like me and the company representative that understands law and law documents. Because had this person consulted with me, I would have said, don't sign the document.
Did they understand?
This person, they say it was what you are saying. So he's a lame person. Whatever you explain, it does not make sense. But we managed to nullify, and the person was reinstated. Now this happened on the 18th of November. We agreed, signed a settlement agreement. The person gets reinstated, start on Monday. On Monday, the person starts, the shop steward is called to the office to accompany the person, and then they give him a notification for a disciplinary hearing. Coming from the CCMA. For the very same thing that they charged him for in September. They have a disciplinary hearing yesterday. Today, I'm told that they have dismissed the person. Again. So these are the problems that we are sitting with now. Now imagine this person was doing, and there's another one that was dismissed with him, but that person was not a member of the union. I think that featured in some of the questions that you asked your potential employees and so on. So your potential employees are members of the union, and employees who are not members of the union. So this one happens to be, the person was a member of our union and then resigned from the union. And when he resigned, we have no obligation to represent him because he's now a non-member. Now, this one comes back, disciplinary hearing today, the outcome is dismissal. Now, meaning that I must now start the process again and refer the matter back to the CCMA. Because now it is on different grounds now. Because in actual fact, that is what I would have wanted the company to do back then.
Yeah.
And not coerce the person, because MSAs are very, very, very difficult. Now you have to make a distinction as to you're gonna approach the CCMA on a different level, or you approach the labor court in terms of reviewing and setting aside that agreement. So I had to choose between the two, and I chose this one. It worked. Person was, now they've dismissed the person.
Yeah, but I mean, the second time they dismissed him, the MSA was not involved, and in the first time that MSA was already nullified.
Yes, but
so my understand. Can you hear me?
Yes, I can hear you.
Yeah, my understanding is that you had the avenue of approaching the CCMA again now on this dismissal, which now does not include an MSA.
The MSA, yes. No, but the MSA will be part of my presentation.
Okay.
MSA will be part of my presentation, because I have to start where it all started.
Yes, you have to.
Because now they are charging the person. They are charging the person for the second time
for the same offense.
The same charge.
Yeah.
For the same offense twice, double jeopardy.
Okay, so let me just, because basically with that statement, I was comparing the contractual agreement between the labor broker and the client with the contractual agreement, which is between the union and the employer. All right. So basically, when in answering me, you said the labor broker gets a tender. They get a tender from the client, right? But the union gets a recognition agreement, which is a document.
That's correct.
Right? Yeah.
Yes.
So basically, wouldn't you say that the labor broker, because the labor broker in that document, they are deciding on what work needs to be done for the client by the labor broker's employees in this case, which are basically fixed term employees, right? Okay. So, and therefore, in discussing that, they are bound to discuss the basic working conditions of employment with regards to that work being done, right?
Yes.
Yeah. So basically, I'm saying that is similar to the bargaining agreement, the recognition agreement, and so on. These agreements that unions have with the employer with regards to the basic working conditions. That's basically where I was.
No, those are. Yeah, but those are different in the sense that your labor broker enters into a service level. The labor broker would enter into a service level agreement.
Okay.
With the employer.
Mm-hmm.
And that's a service agreement that deals primarily with the services that are to be rendered and the fees that goes with that, how they charge and so on, service level agreement. Now, the collective agreement talks to relationships. It is a relationship that a union will have with the employer. So this one is about service level agreement. This one is called a recognition agreement or collective agreement that regulates the relationship between the employer and the union.
Yeah. Okay. So now
somehow they sound to be the same, but
they're not
now,
the same.
They're not actually. But the service level agreement also regulate. Yeah, it could be actually. Come to think of it, you know. And now that the more I explain, the more it wants to make sense. Remember, this service level agreement would basically relationship, whether it be in terms of how they get paid and what kind of services they render. Yeah, basically the same. But now, we talk about money and so on.
Yeah.
This side we don't. Yeah, you are right. It is actually the same thing. Yes, you are correct. The more I actually explain, the more it makes sense.
Yeah. So basically,
right. Yeah.
Just a last statement. Remember, there's 3. So that was the second one. The last one.
Yeah.
So a broker is a juristic person as an organization, right? It's considered a juristic person with its You've identified them as fixed term employees. These are the employees that it sends out to do work for clients, for the tenders that it got. And it also has its own sort of administrative staff, who are its own permanent employees, right? So
yes.
the administration, HR and so on, whoever they have there,
yes.
right?
Yes.
The union is also a juristic person, okay? And it also it doesn't have fixed term employees; it has members, right? And also its own administrative staff.
That's right.
So now I'm comparing the two. I'm comparing the two to say the similarities is that the difference here is that the fixed term employees of the labor broker are members, when it comes to the union. The union doesn't have fixed term employees. It has, but basically the labor broker sends out its fixed term employees to go do work, and the union can deploy its members for things like strike and so on, strike actions.
But I think it would basically work better. I think we dealt with it differently. But the labor broker, remember the employees that work for the labor broker are then sent to go in and render a service to the client, right? Then that being the union has members. You can also say the union also have staff members, such as your union organizers that work for the union, the union officials that work for the union to the members. Render a service to the members. So in that sense, it would be a good way of putting it. Okay. That's a way of it's similar to, because this is what they do and this is how we do it. Okay. It's the same way. Rather than saying employees. All
right. Look, let's leave it there for today. I think